A client of ours bought a new property in White Rock, South Surrey, and he thought it was under warranty, and it really was not 100% under warranty as he'd thought, and it turned into a nightmare. Hi, this is Ken Pasder. I'm a real estate lawyer in downtown Vancouver, British Columbia. The firm is Pasder Law Corporation. We are a residential real estate law firm. To date, we've closed about 30,000 residential transactions for clients, and we continue to do so. The problem could have been avoided by having the lawyer review the transaction before it happened, but unfortunately that's not the standard practice in British Columbia. The situation involved multiple failures by different service providers in the transaction. The realtor made a mistake, the home inspector made a mistake, the warranty was not properly put in place to begin with, and in fact a good portion of the warranty had already run out before the transaction had even been closed, and that was not known to the buyer. And unfortunately, the buyer has inherited a huge lawsuit, and he's now having to sue everyone. We suggest to our clients that as one of the subject conditions in a real estate file that they put in a subject condition saying subject to review of this contract by my lawyer by a certain time. So they're going to put in other subject conditions like building inspection, title review, those sorts of things. You just put one more in saying subject to my lawyer looking this over before we make it final. Unfortunately, that doesn't happen very often, except with our previous clients where we've already told them to do that. But certainly the rule in BC is that is not done. Now, could we have helped out on this file? Yes, we could have. Once we saw the file, we could have informed the client that the warranty probably had run out, or at least the significant portion of the warranty had run out, and they may have stopped the file at that point and not bought the property. Part of the issue of educating clients is that they are not aware of the different types of legal service models which exist in British Columbia. And there's a transaction model and there's a relationship model. And the transaction model is a low fee, high volume, no service, no advice. So you get what you pay for, the title is transferred, that's it. The relationship model, which is what we use, is high service, high legal advice, lots of education, and unlimited follow-up. So the client for us is a long-term client. They tend to come back. We want to ensure that they have a good experience, that the property is properly conveyed, but also that they are protected to the extent possible.